to licensing hearing this morning, 1st of October. The chair for this morning's committee is Councillor Peter Abraham. We have Councillor Fee Hants present, and just so that everyone is aware, we are quorate, so we are proceeding with the two councillors present. Councillor Peter Abraham, may I ask you to do the usual introductions? Thank you very much and welcome. Thank you.
Thank you, Claudette. Good morning, everyone. Peter Abraham is my name. I represent Stoke Bishop, and my colleagues are here. We will introduce one another, I think, so that we all know who we are. So if I go along the line, Lynn, you're next.
Good morning, everyone. My name's Lynn Harvey, and I'm legal advisor to the committee today.
Carl.
Thank you, Chair. Good morning, everyone. My name's Carl Knights. I'll be providing licensing policy advice to the committee.
And my colleague Fee.
Morning, everyone. My name is Councillor Hants. I noticed that my name's not right. Claudette, would you mind awfully changing that for me? I'm sorry, I've just tried and I can't. I'm the Green Party councillor for Redland Ward. Thanks. Sorry about that, Claudette.
Next on my line is Julian. Could you unmute, Julian?
Hello.
That's right.
Yeah, hi, I'm Julian. I effectively sort of own the I run the Cadbury, or own the lease to the Cadbury.
Thank you. Crispin?
I'm Crispin Busk. We live, me and my wife Jo, we live next door to the Cadbury, number 70 Richmond Road, and downstairs flat.
Thank you. Jeremy? You need to unmute, Jeremy.
Good morning, I'm Jeremy Woodcraft. I'm the solicitor representing the applicant company, which is Event Bars Limited.
Thank you. Tony?
Hi, I'm Tony Mason. I'm a resident of York Road. I was one of the people who was involved in the objections which in 2005, which established the current licensing regime for the Cadbury House. So I've got an interest in that respect, just to see how this one turns out.
Thank you. Mark? You need to unmute, Mark. Unmute.
There we go. Yeah, sorry. Yeah, Mark Curtis from Bristol City Council Pollution Control Team, deal with noise complaints.
Abby?
Morning, thank you, Chair. I'm Abby Holman. I'm a licensing officer, and I made the rep on behalf of Regulatory Services, which includes the Pollution Control Team.
Kurt?
Yeah, hi, morning. I'm Kurt. I live next door to the Cadbury, number 70 Richmond Road, top floor flat.
Oliver?
I live on York Road, opposite the pub.
Thank you. I've got on my list, but no picture of Ollie Webb. That you there?
Yes. Hello.
Good.
I'm tech support for today.
Good. Anybody else that wishes to be introduced or is part of it that we haven't mentioned? Nope. All right, we'll go on. Normally at this point we have safety and instructions and all the rest of it, but as you're either not with us, I'm sure if you something goes wrong and you've got a fire in your house, you will get out. We will if there's one here in my house, I assure you. So I'll leave all that for today. The one thing that I think that we've got to be sure of is we've done Zooming quite often now, and it's very satisfactory. But one's got to be sure that everybody gets their chance to speak when they wish to in the correct areas of where they are allowed to speak, and that we are transparent in what we're doing. So we'll try our best. If there's anything you don't understand, really like some explanation to, please tell us and flag us down and say, look, I really need some help on this, and we'll do it. And obviously, if we want to break at any time, that can be suggested, and we'll do that if necessary, if you want some private talking. But we'll take it as we go along. And as I say, normally it's very satisfactory. We've had a lot of representations, so we'll deal with those when we get to them. I don't think there's anything else I need to say at this time. No, I think that covers it all. What I want to be sure of is who's representing who. Jeremy, you're going to do it on behalf of the applicant? Is that right?
Could I
Yes.
suggest that we run through what the process is for those who aren't familiar with it?
I think we need to do the process pretty clearly. Thank you. Yes. What we'll do is we'll look to our officers to introduce the application so that we know exactly what we're dealing with. And then we'll probably go to Jeremy, who we can make some opening remarks. And then we get a chance to go into a discussion. It's not a court, so let's be clear about that. And so we can talk and ask questions and find out exactly what we need to know about that. And we will be looking for a summing up. Now, those that have made representations, I don't know how you're going to do it. I think they're, if you all wish to say something, that's possible. But it might well be that one or two of you can cover the points that are being made that you agree with. But I think in these circumstances, there is a lot of representations and relatively few, here to make them so in person. So we'll deal with that. But I want to take notice of all the representations that have been made. And then once we've felt that we've covered the point, I'll be looking for a sort of summing up, and I'll look to the various bodies to just do some closing remarks and just remind you that at that point, there will be nothing new introduced, because it's just to sum up exactly the points that have been made that you wish to emphasize. Are you fairly clear with that? Any questions arising out of that? Nope. All right. Formally, I have to ask for declarations of interest. That's from us as members, and I've no interest in either of the applications we're dealing with today. Fee? No interest declared. So hopefully, how are we? Have we any official public forum, or are they the representations we receive will be heard during the course of the hearing? No official public forum. That's right.
Public forum.
Thank you very much indeed. So we move on then to the application itself. And is that you, Carl? Are you introducing this on it, or is it Abby?
I will. It's myself, Chair.
You good? So if you'd like to introduce the application before us.
Thank you, Chair. So as we're all aware, this is an application to vary the premises licence of the Cadbury House on 68 Richmond Road. The current licence authorises the sale of alcohol on Sundays from 12 midday to 10:30 in the evening, and Monday through to Saturday from 10 until 11. It's effectively an old converted licence when the Licensing Act changed, so there's no opening hours specified on the licence. In effect, they're at the discretion of the licence holder, and there's no application to change to vary that. So they'll remain as they are, which means in effect it could be open 24 hours a day, although obviously they're limited by the activities they can provide. They're now seeking the sale of alcohol from Monday to Sunday, 7 days a week, from 10 in the morning until 1 o'clock the following morning. And the application also seeks to remove the following condition, which is the garden area, including the lean-to conservatory area, shall be cleared of customers by 2200 hours, except that persons shall be permitted to use the outside garden area for smoking until 2300 hours, but such persons shall not be permitted to take beverages or food outside with them. We received representations, as you're well aware, from the police, who have agreed, subject to a number of conditions, which I'll cover in a moment, and regulatory services who are here today, Mark Curtis particularly, who will be able to speak on with regard to the representation. We also received 55 representations. You'll note a number of these didn't contain the full name and or the address of the person making the representation. And we have contacted those people to ask those details to be provided. Some of those details were subsequently provided, and you may take those reps into account. I'd ask you to discount the representations that we didn't receive the full name or address for. A number of conditions were agreed with the police, as I say. A lot of those conditions, they're in your papers anyway, are effectively standard conditions in relation to CCTV, underage sales training, and so on. The condition of note is, in effect, one to replace the outside area condition. And what's been put forward is that after 2300 hours, the only persons permitted to use the outside area will be those wishing to smoke, and only then in accordance with the following restrictions, of which there are 6. The first is that no more than 5 people will be permitted outside at any one time. Those persons will only be allowed in a defined area to be located as far away from the surrounding properties as possible. No drinks to be allowed to be taken outside. The doors will remain closed, safe access and egress. Signs will be prominently displayed reminding persons to be quiet, and there should be no entry or re-entry to the outside area after midnight, and appropriate signage to be displayed to that effect. You'll note in the representations reference was made to an abatement notice, and we have clarified that with pollution control. Mark's here today, and he can correct me if I get any of this wrong. But my understanding is an abatement notice was served on Cadbury House, but that was back in the 1st of May 2007. It was served on the then licensee, premises license holder, and manager of the premises. That notice would only be enforceable against those persons, and they left, I believe, 12 years ago. So that notice effectively is no longer enforceable. In any event, off the back of that abatement notice, there was a review, which you've obviously seen reference to in the papers and from the letter from Mr. Woodcraft. That review resulted in the condition that's they're now seeking to remove. Excuse me, I'll get my voice back. As you'll see in your paperwork, there has been a letter sent to all parties which details the conditions that were agreed with the police and the applicant. We have had one email back from a Mr. Lewis Davies Smith, who was one of the relevant persons. He's unable to attend today, but he just wanted to be sure that members were aware that he's not happy with the conditions agreed and feels that the use of the outdoor space until midnight would still have a negative impact on the licensing objectives. That concludes my report. Thank you.
You need to unmute, Councillor. Chair.
Can you hear me now?
You can.
Ah, good. Went back on. Thank you, Carl. I think that's all straightforward. I'll go straight over to you, Jeremy, if I may.
Good morning, all. Jeremy Woodcraft. I'm a solicitor from Keystone Law. We're based up in London. I'm here this morning representing the applicant company, who are Event Bars Limited. Mr. Julian McLaughlin, who is also on screen, is the director of Event Bars and is very much the man who has developed Cadbury House since 2008, when they took it over. At the outset, Mr. McLaughlin was keen that I expressed the fact that we didn't want to cause as much concern to the residents as we seem to have done. There has been an overwhelming objection, and clearly he has worked very hard to create a premises that does seem in some regard to be welcomed by any number of residents, and he doesn't want this application to in any way interfere with that relationship that is built up. Unfortunately, by dint of the regulations, as the committee will be aware, it is very difficult to really convey much information in the public notice, an A4 piece of blue paper, and obviously a very small newspaper notice. So, as I say, probably an apology at the outset. The reasons for the application are several, but fundamentally, we will hold our hands up and say that obviously there is a commercial element to it. it is geared to give a degree more flexibility in the way we operate to ensure that the business is sustainable going forward in both the medium and long terms. And that will perhaps not surprise you that we're looking at things perhaps in the slightly shorter term as well as the permanent change that would occur. There has been reference to the history, and I think it is very relevant to just briefly outline how the premises has come to where it is today. You have heard that in 2005, the licensing officer has explained this was what was called simply a converted license. There is reference in the resident representations to the fact that they actually made application at that time to vary the license, but that application was refused. Now, I don't know whether that's right or not, but if that is the case, then it suggests that in 2005, there were significant grounds to warrant refusing any kind of variation. So it was just a converted license. Leading on from that in 2007, I believe, clearly matters didn't improve and a review was called, which resulted in the only conditions that really are attaching to this license other than the mandatory ones being imposed. And those conditions centered really on the noise nuisance and the pub in particularly was a live music venue, so that was very much to the fore. So the condition that we're looking at in terms of the garden came about as a result of the review that was, as I say, undertaken in 2007. There is, I think, some concern amongst some of the residents that there may be a return to the bad old days. Mr. McLaughlin took this premises over in 2008, and he says it was not an instant turnaround. He had to really pour his heart and soul into it to deal with problems that the premises was experiencing and the problems that it was causing in the neighbourhood. It was, as I say, a live music venue. There is reference in the residents' representations to drug problems, and that was very much the case. And Mr. McLaughlin says he really had to pour everything into it, turn the pub around, and indeed, even to the extent that he put his own physical being on the line, being threatened on several occasions to remove the clientele who were at that time undoubtedly not contributing to the licensing objectives. I think it is fair to say that the residents have been very even-handed in their representations, and clearly the success of Mr. McLaughlin's efforts can be seen from those comments. These are extracted directly from the residents' comments, and it has been described variously as of value to the community, a welcoming family public house and restaurant, and one resident even going so far as to describe it as a great gem. Another operator recognises the efforts that Mr. McLaughlin has put in and says that he is I'm just looking at the words that were used here, a considerate proprietor or operator. So I think so there is, as I say, a very even-handed approach to the residents, and I think we take on board their comments, obviously. So that really is the background, that we've got a very strong management situation that's got us to the position we are, that we are asking now for an extension to assist in the sustainability and the long-term existence of the premises as it is. So there are two aspects. One aspect is the condition relating to the garden, and you will have seen any number of objections relating to that. Obviously, when the application was made, we could only say we want to remove this condition. The public notice not really facilitating anything further, but you would have seen now there is a fairly lengthy and detailed condition that we would suggest, and indeed the police have agreed, would be a suitable replacement for that. And so obviously the use of the garden is, if you like, ancillary to the main thrust of the application, which is the extension of hours. One thing I would say about that condition, sir, obviously you probably see fairly wordy, lengthy and quite complicated conditions such as that. It is about management and it is about enforcement. And if those conditions are managed and enforced as intended, as Mr. McLaughlin clearly can do from his track record, then we would be confident that the licensing objective of public nuisance would not be compromised. Moving on, therefore, to the extension of hours that is being sought. I said there was a medium term and a longer term objective. Well, in the short term, obviously, it is all utterly irrelevant because everybody is closing at 10 o'clock. So this clearly isn't a short-term issue. In the medium term, one must assume that with everything hopefully going in the right direction, there will be a relaxation of some of the restrictions that are currently in place. So one would hope, for example, that you will see a restriction of 10 p.m. being removed, but in the medium term, I think it is entirely probable that we are not going to see a relaxation of the social distancing rules, the rules that there must be a 2-metre gap or 1 metre with mitigation, and therefore the public house is going to probably have to live with the kind of internal restrictions that are currently in place, assuming, as I say, that, that these restrictions are listed. The other assumption that we are making, of course, is that this premises does actually make it through these very difficult times. Several thousand pubs probably haven't, and several thousand more probably won't. But making those two assumptions that there will be a degree of relaxation in the medium term, the reality is that with the regulations as they stand at the moment in relation to distancing of tables, the capacity internally is about 30% of where it would normally be. Now, up to this point, the premises has been very lucky in that it has a garden and it has been able to have social distancing tables outside, and people have been able to sit outside, and it has taken the pub slightly back towards something that is sustainable. Obviously, we're now moving into winter, and with the best will in the world, nobody's going to want to sit in the garden in 9 degrees and drizzle. So in the short term, obviously, this application would give a degree longer to accommodate slightly more people and move that 30% figure slightly back towards a sustainable objective. Certainly, the operating costs don't change. When the pub is open, it costs what it costs. So it's a very much challenging environment. And also, sir, obviously, if we only can accommodate 3 out of 10 people or 30%, it may be that with slightly longer opening hours, as we have sought, it will enable people perhaps a window of opportunity to come in when they might not otherwise be able to because of the capacity limits. So that, sir, is the medium term. In the longer term, and we all hope that everything gets back to normal, but in the longer term, sir, you will have heard the arguments on many occasions. The Licensing Act of 2005, or implementation in 2005, didn't achieve the cafe society that was hoped for, but it did have an influence on the way people socialise and people's expectations in terms of the time they go out and the times they want to come home. And obviously, this application would recognise that and give a greater degree of flexibility to those persons. So effectively bringing the licence perhaps into people's current expectations in how they deal with things. There is potentially an ancillary benefit to that, sir, from a licensing objective point of view. At the moment, Mr. McLaughlin would say any number of people from the locality come to his pub, but then later in the evening, wanting or expecting to be able to extend their evening, will head off from the pub, perhaps at 10 or 10:30, off to a premises with later hours. And then obviously the corollary of that is that later in the early hours of the following morning, they may well be coming back and going home. So to that extent, if the hours were extended, an argument you will have heard many times before, but one that has some validity, effectively avoids a double movement of people. The other more practical, pragmatic aspect of an extension of hours is that clearly if we close the pub at 11 o'clock, it is likely to have far more people in it, all of whom will leave at the same time. The reality is that if the hours are extended, people tend to leave in smaller groups, hopefully mitigating the impact on the immediate neighbourhood. But both arguments, sir, that you will have heard, I'm sure, on many, many occasions. Sir, I've talked about management, and management is all in these cases. If management is strong, then problems can be avoided. Mr. McLaughlin and the company own 3 other venues in the Bristol area, all of which have similar hours to the extended hours being sought here, all of whom have more liberal or indeed no restrictions on the use of the garden. And in each of those 3 cases, Mr. McLaughlin and Event Bars can say they work well within the community. They are not problematic. So again, evidence that with proper management, things can be done in a way that will not upset our neighbours and will hopefully keep us as a relatively welcome part of Richmond Road. So, so There are a couple of points that I would raise. Obviously, Mr. McLaughlin would say, to his knowledge, there haven't been any recent issues or noise complaints. Clearly, he said when he first took over, there were issues, and it took some time to work through those. But recently, there's been no issue. Certainly, we haven't seen any schedule of complaints or noise issues from the environmental health officer, which would tend to support that. So it does seem that Mr. McLaughlin can demonstrate from recent evidence, as it were, or exercise, that he can manage things effectively. The other aspects that I would ask you to consider is that your police officers and indeed your licensing enforcement officer in their representation both don't see the extension of hours as necessarily a problem, as a problem that is going to adversely impact on the licensing objectives that couldn't be dealt with by robust management, and that they say effectively as much in their representations. And so you will be mindful of the fact that the police and your licensing enforcement team deal with hundreds probably of pubs in residential areas, and so they really do hopefully know what they are doing. There are a couple of other points that I think are worth making. It is mentioned that this is a converted license. It has none of the conditions on it that you would expect to see on a modern license. And from a police...
Hello, you're back now.
Can you hear me?
Yeah, I haven't been able to hear the last 2 minutes, I would imagine.
You probably haven't missed much. So where did you get here up to?
Did others experience a problem?
No, I think it might be you, Peter. Sorry.
Yeah, I was just watching it and it just stopped, and then it's just come back.
Same for us.
We couldn't hear either.
They couldn't hear either, so it was general. If you could go back a little bit, Jeremy, please. Sorry.
That's fine. Where did you hear up to?
Is properly was it the hours that currently don't generate any complaints, and therefore demonstrated reasonable management, and that the proprietor was able to control. I got all that, and then it sort of went from that bit on, really.
Fine. I'll start from there. I think in essence the point was probably made that Mr. Curtis, who is present today, hasn't put forward a list of noise nuisance complaints, and hopefully that does back up.
Yeah.
Fantastic. Moving on, the next point then, so that seems to be where I dropped out, was that you have obviously police and in licensing enforcement representation, and it is worth noting, and I would ask the committee to put store by this, that neither think that the extension of hours would necessarily adversely impact on the licensing objectives, particularly with hopefully the strong management that is in place. And so I would ask the committee to take note of the fact that obviously both the police and your licensing enforcement team have experience of probably hundreds of premises in residential areas around Bristol, and therefore would hopefully be in a good position to make such a value judgment. My sort of final point, sir, before I draw to a conclusion, which I'm sure everybody would be pleased with, is that this is a converted license and it doesn't have any of the current restrictions or conditions on it that you would expect to see. From an enforcement side, sir, obviously that is problematic for police and indeed licensing enforcement. There aren't conditions on there such as CCTV, the requirement for an incident book, challenge 25, all the sort of major conditions that you would expect on any kind of license, because, as I say, it was converted and the only conditions are by dint of the review. So the applicant has agreed with the police that should this variation be granted, all of those conditions that will bring the license up to date, if you like, bring it from the old justices world into the modern day, will be imposed. Obviously, the obligation in terms of CCTV is an expensive one, but the applicant is willing to invest in that. And obviously the other management conditions that are probably being adhered to anyway, but will help the police and licensing enforcement going forward. So that really is the nub of it. So in summary, therefore, what we're looking at is possibly a request to give a degree more flexibility, perhaps bring the license to reflect current expectations and current customer demand. On the other side, we are offering the conditions and restrictions such as CCTV, etc., that would equally bring the other side of the license up into modern times. So in summary, therefore, this is, as I say, we hold our hands up. This is obviously a commercial venture. It is about making the premises sustainable in the medium and longer terms. Clearly, sir, if it's not, this is a premises that's owned by a very large pub company and will undoubtedly move on to another operator who one suspects may not be quite as robust and considerate, shall we say, of the surrounding neighbourhood. So that, in summary, is the application. Obviously, we'd be pleased to take any questions from the councillors if we can assist.
Thank you very much indeed. Perhaps I can just stop the thing going. For me, this is obviously the main point about not the circumstances we're in today, because hopefully we're not going to be in for those for a very long time. I know in the short term, but I think that the extra hours mean nothing in the short term anyway, do they? You know, we have to deal with it. What I am concerned about is the long term and the very final point that you made. If we agree to this, that will be the license, and somebody else could come along that perhaps will not have the skills and the management wherewithal that you talk about to be able to manage it in the way. And we're faced with a public house that is very much in a residential area, cheek by jowl, with people living very, very close indeed. And I think that we've got to be pretty certain that there's justification for a local pub in a residential area to have the sort of hours that are being suggested. And I think there is a lot of representation, and you're absolutely right. I mean, one of the things that is interesting to read, that they're very even representations, starting off by saying, we love the pub, it's a super pub sort of thing. But there is a feeling that these hours will cause them a real nuisance. And I'm not convinced, or I'm there to be convinced, if you like, that these hours can be managed in the way that you're saying. Direct question, by the longer hours, will you feel that they'd be serving the same clientele, or is this to attract different and newer people who want these longer hours? And will they be a different sort of customer to the ones that a good relationship has been taking place between the public and the licensee?
Thank you, Chair. Just picking up on your point in terms of the potential change, and you're absolutely right, licenses last forever unless otherwise revoked. Mr. McLaughlin has a long lease from Enterprise, so he is committed to the public house, very, very much committed financially for the next 10 years at least. So in terms of long-term commitment, Mr. McLaughlin is in there up to his eyeballs, as it were. In terms of attracting a different type of clientele, that is absolutely not the objective at all. This isn't a public house that is in that market. It is very much what it is, and it is, as I say, from Mr. McLaughlin's experience, of people who currently come there who, as he would say, move on elsewhere looking for slightly later hours. So no, categorically not. The other perhaps pragmatic thing is that this is looking for a degree of flexibility. And the reality is, Mr. McLaughlin would say, it is not going to be 1 o'clock every morning. People aren't there. The market isn't there for 1 o'clock during the week, etc. This will probably be very selectively used. Obviously, we would look at probably the weekend days as being the days when we might use the extension. So to that extent, it is perhaps more than we would actually make pragmatic use of.
Thank you. Councillor Hans, have you any questions, please?
I do, unsurprisingly. I've got a couple of questions possibly for officers. whilst we've got every sympathy with the financial constraints on the entertainment industry at the moment, it's obviously really, really grim. What weight can we give those financial considerations in our deliberations? Because my understanding is that we stick to the 4 licensing objectives. So whilst we can have immense sympathy, that's not something we should take into account. I'm just checking here. There was something else, and it's got something about the noise abatement. I mean, if people are coming out at 1 in the morning, can you just clarify for us what measures you can take? Because 1 in the morning is pretty late for people to be coming out of a pub, even on a Saturday or Sunday, or Friday or Saturday. So can you spell out for us what measures you're willing to take to try and keep that noise to a minimum? Thanks.
Councillor Hans, did you want officers to answer first? Because the first question seems...
Sorry, yeah. First one for the officers, the second one for the applicant. Thank you.
Yes, I'd confirm that you are right. The commercial aspirations of the applicant aren't relevant to the licensing objectives, and there's no presumption that applications ought to be granted. So that's the first thing. Obviously, your main focus is promotion of the licensing objectives. There's one other thing I wanted to come in on regarding the outside area, just some policy advice and also some legal advice flowing on from that, which obviously give Mr. Woodcraft the opportunity to respond to. Your statement of licensing policy does deal with noise from customers in outside areas and talks about that being of more significance in residential areas and also where outside areas are used after the hours of 10 p.m. And that noise from customers can still cause a nuisance even when those customers are not behaving badly. So generally, this licensing authority has adopted a consistent approach where outside areas generally are cleared of customers by 10 p.m. Some premises licenses have a curfew that's slightly later of 11 p.m. But that's normally your policy starting point. And leading on from like the legal position from your policy, the general position is that where a local authority does have a policy, then the onus of proof is on the individual seeking to be treated as an exception to that policy to show that an exception can be made without undermining it or the reasons that underlie the policy. So the applicant should really address you on why, in this particular case, that an exception from policy should be made. I have to admit, I haven't seen the condition that's been agreed with the police. I've asked Carl to send that to me. So obviously that's something you need to take into account. And as always, each application has to be considered on its own merits, but that is generally what your policy starting point is in regard to outside areas. I think if I can just pass over to Jeremy now to address you in regard to the second question that you raised. Thank you.
Jeremy, can you unmute, please?
Can you hear me?
Yes, now we can.
Thank you. Right. Yes, so firstly, perhaps taking the councillor's point about, or the question really that was aimed at the legal advisor in relation to financial necessity or financial sustainability. No, that is not obviously part of the considerations in terms of the licensing objectives. Clearly, there has to be a reason for an application. We are not being disingenuous. That is the reason the application is made. What is relevant and what has to be taken into consideration is the promotion of the licensing objectives, which in this case is nuisance, public nuisance in essence. There is no other objective really that is really in play. And what you have to consider is there evidence, can you see evidence that would say this will not have an adverse impact on the licensing objective of public nuisance? And what I hoped or hope you will take into account is firstly the strong management that has put the pub in the position where it is, the fact that this pub has other track records, if you like, within Bristol without problems, and that with robust management, this can be done. And this comes from an operator who clearly does have those skills and those capabilities. In terms of the outside area and the policy, Your legal advisor quite rightly makes the point that several premises do have the 11 o'clock cutoff, and that is part of the restriction that has been agreed with the police. The caveats and conditions and detail that goes thereafter is solely to accommodate the relatively small minority of people who smoke. So in terms of that, the condition that has been agreed is consistent with what your legal advisor has said. So that picking up really on those points, it is, as I say, it is for you to look at the evidence that is available and the evidence that has been put forward on behalf of the applicant. In terms of leaving, which I think was a question at 1 o'clock in the morning, then obviously the objectives are that you have signage which has been discussed, you have on-site reminders, and obviously you have, as I say, this diminution in the number of people leaving at that particular time. And clearly, again, that comes down to a management point, and we would feel confident that we could deal with that.
Thank you. Would anybody else who'd like to say something at this point indicate that they would like to speak? Please, Carl, yes?
Thank you, Chair. It was just one query regarding smoking at the premises. Obviously, there's been a condition agreed regarding the use of the outside area. And my understanding, but correct me if I'm wrong, Jeremy, is the wording relates to the land owned by the premises, so the garden and the bit around the side of the premises, obviously not the public highway at the front. I just wanted to inquire, do patrons currently use the pavement at the front of the premises to smoke?
So perhaps that's one that Mr. McLaughlin could answer. Obviously, sir, I don't have first-hand experience of the premises.
Can you help us there, Mr. McLaughlin?
Yeah, sorry. Can you hear me? Yeah. You do get a couple of people now and again at the front, but generally people are use the back.
Thank you. Anybody else wish to make a contribution at this point? Thank you. Perhaps, Mark, have you got anything you want to say to us at this stage? Abby? No. All right, let's have a look at the representations that we've received then. As I say, received quite a number and I've read them all. There are representatives of those that have sent in with us. Anybody like to start on their behalf, on your behalf, of putting your points to the committee, please?
Chair, just Abby would like to.
Yeah, Chair, apologies. When you asked whether I wanted to speak, I didn't know whether you meant in response to the applicant's submission or.
Well, I think that's what we're dealing with at the moment, but I am moving on really because it seems as though everybody, nobody's further points directly what Mr. Woodcraft has said. So it seems a good point if you wanted to say something to make your representation now, if you like, please.
Yeah, of course. Thank you, Chair. So obviously I'm here on behalf of Regulatory Services, and because this application primarily relates to issues around noise nuisance, obviously I've invited Mr. Curtis along as well to give you a view specifically on the noise nuisance and any issues that have occurred in the past at the premises. You've obviously had a copy of my representation. I would like to amend slightly what Mr. Woodcraft said about the inside hours. We don't have an objection as long as it's appropriately conditioned. So we haven't suggested any conditions that might be appropriate. I think that's a matter for you to look at and whether you're satisfied with the police conditions and the hours overall. So, you know, we would leave you to determine that, but we don't have any strong objection to that inside times as long as it is appropriately conditioned. With regard to the removal of the condition around the outside area, that is something that we do have a strong objection to. We have just very recently seen the police conditions that have been suggested and agreed with the police. And I think they are a step in the right direction. But I think Mark would agree with me in saying that there are still some concerns around the 10 to 11 period, and then also the management after that 11 o'clock time, because as Lynn has said, the policy does normally restrict pub garden opening hours to 10, with some exceptions to 11, but generally it wouldn't go later than that in this sort of residential area. The condition obviously was imposed as part of the review brought about by Pollution Control in 2007. We don't appear to have had any further complaints. We would suggest that maybe that means that, as well as, you know, Mr. McLaughlin running the pub very well, that condition has appropriately been, enforced, and therefore complaints haven't been received. The garden area, as I'm sure you're aware, is boxed in around by quite a lot of residential houses, and the gardens do back onto them, so it is quite close to those houses at the back. And yeah, we are quite concerned still about that outside area. Mark, if I hand over to you, can you talk about maybe a bit about the review and the sort of the noise concern specifically?
Okay, Mark.
Yeah, bear with me a second.
No problem.
Sorry, I just got some notes here which I'm trying to open up and it's not letting me get to them. Yeah, the review in 2007 was taken really just because of noise from the garden. Originally, we did have complaints about music as well, but the then operator managed to resolve those issues, and those complaints, we didn't get any more complaints at that time. The complaints which led to review were noise from the garden, and those were generally happening between 10 and 11 p.m. From those neighbouring residents whose houses are very close to the pub garden. From the notes on file and the review documents, the noise complaints were not generally due to customers acting unreasonably or in a rowdy manner, but due to numbers of people, just the numbers of people, of people using outdoor area, enjoying themselves and having a few drinks. Although this type of noise will be more significant the later it gets, it can be a nuisance at any time. And so I think, quite rightly, as everyone said, it's our licensing policy. We have the 10 p.m. cutoff time, and the implication or the imposition there of the closing of the garden at 10 p.m. seemed to strike a balance of allowing the garden to be used up to a certain point, but also offering some respite to local residents. And I would confirm that since then, we haven't had any complaints about noise from the garden. I'm also not aware of any complaints recently regarding the pub at all either.
Thank you very much indeed, Mark.
I just add as well, Chair, I think in light of what Mr. McLaughlin said about the front area occasionally being used for smokers, obviously it hasn't been raised as a significant issue in the reps, but it may be appropriate for you to consider conditioning, if you are minded to grant this application in any form, conditioning the front area in a similar fashion to the back area, just for consistency.
Thank you. That's noted. Okay, anybody else, any points they want to make at this time, or shall we have a look at the representations that we received? Any of the residents wish to say anything at this stage? Indicate if you do, please. No? So, oh, please, Crispin.
Hi there. Sorry, is this the bit where we sort of get to say how it would impact us and stuff, or is that?
I'm hoping you will.
Okay,
We've read all your submissions,
yeah.
but it's good to hear you underline the verbal bit of what you feel are critical and important, and interesting to have your views of what you've heard so far, really, where we are at this moment.
Okay, thanks. Yeah, I suppose.
Sorry, Chair, just before Mr. Busk starts, apologies. If you have no questions for me, and if the applicant has no questions for myself and Mark, we're going to depart from the meeting, if that's okay. We are available all day if needed, and Carl can contact us. Is that okay?
Anybody, any questions they wish to ask from Abby? No, Carl is staying though, aren't you? Yeah. So, thank you. Thank you very much indeed for your contribution.
Thank you all.
Release you. Right, back to you, Crispin.
Okay, thanks. Yeah, just sort of saying, as neighbours of the pub, just as things get later, it is just noisy, and if you are trying to sleep, and if your kids are trying to sleep, and everything else, the later that things are happening, then the more that does affect you, really. And even when there are lower numbers, if you like, when it's late, those numbers can just be noisy. And even with the management and things like, if we're honest, things like signs and things don't make any difference. If there are signs saying, please be quiet, people don't really take great big notice of it. And then people have to come out and say, can you be quiet? And then people come in and go out and in and out and everything else. And it's the same again with the later kick-out times, that the later that kick-out time comes, the more people there are out on the street and there is noise. And again, even if it's being managed, it's just noisy and kick out and people around and milling around and everything else. So if it does get pushed back, it just have a big impact on the people who live nearby. And people are trying to get to sleep at 11 o'clock, and definitely at sort of any later. I mean, really, kids are going to sleep before 10, and as time goes on, certainly as it gets to those later times, it's a residential area. People are asleep at 1 o'clock. If there are people out and about, it's going to be noisy, even with management. And there are lots of people who live around and about, and I think there are lots of people I know who'd written in, even if they're not here for this meeting, which, to be fair, is at 11 o'clock on a working day, if you know what I mean. So it does make a big impact on the people who live nearby to have these late nights and late garden openings and people in and people out and everything that goes along with it. So it just, we've heard all of the things about trying to manage it, and we've heard the things about, track records and stuff, but I think it's the person on who was the licensing person said that as it gets later, it just makes more and more of an impact on the people who live nearby.
Thank you, Crispin.
Okay.
No.
Chair, would you like to go through everyone by name, the representatives? Chair, you're on mute again. No, you've got,
Should be all right now. It's going off on its own. It seems to have a will of its own at the moment.
Do you want to go? Shall we just ask Mr. Mason next? And if he has any questions for the applicant, he could put it at the same time.
Okay. Right. I'm not an immediate neighbour of the pub. I'm more here as an observer. Everybody that I've spoken to says that, agrees that the pub is well run and they value it. But most had a concern about the later use of the garden. Having read the letter from the applicant, I'm pleased that it's been clarified that that will now form part of the licence rather than being merely an undertaking to the hearing, because there has been at least one instance where a licensee has given undertakings at a hearing which have not subsequently been carried out because they were not part of the license. There's been reference to customers changing expectations, but the neighbours' expectations have not changed. The neighbours continue to need to go to sleep at the same time rather than going out till 1 o'clock in the morning. And from my point of view, one of the joys of the past 6 months has been that it's been possible to have my bedroom window open at night without being disturbed by people coming home in the early hours. But that's a small silver lining in the gloom that there has been in the past 6 months. I think pretty much that's it. I'm pleased at the submissions from pollution control, and I trust that the committee will take good note of them. Thank you.
Thank you. I'll just mute you, Mr. Mason. Chair, you're muted again.
somebody just, as I unmuted it, can you hear me now?
You can, yes.
Thank you. If we could just leave it, be a help. Kurt Taylor, have you anything to say, please?
Yeah, hi, can you hear me?
Yeah, we hear you lovely.
Great. Yeah, just echoing those concerns. So I know Jeremy did touch upon that, the fact their aim was to not attract any new clientele or a different type of clientele, if you like. But I mean, we all know that Stokes Croft is just a short walk down the road. And I think the fact is, if it was open until 1 a.m., it is going to attract some extra clientele, which could bring with it noise. I'm also relay Crispin's concerns about the management and enforcement. I agree that signs, they don't really do anything, especially after people have had a few drinks. And I mean, would it be down to the bar staff to enforce these people to obey to the rules, or would I would imagine that additional security staff would be needed to enforce those, which would again come with costs. Currently, as soon as people leave the pub at the moment, as far as I'm aware, nothing's enforced. So as soon as people are out the front door on the road, they're just sort of left to it. And people do tend to hang around and have another cigarette or wait for a taxi. So if the pub did close at 1 a.m, when they would be out, they'd be outside on the front of the road, then that would bring us to sort of 1:30 a.m. sometimes getting taxis, which again, on that residential road, just it can't really happen, I don't think. And lastly, I do fear if it was granted that all of Julian's hard work would be undone, just mainly due to the fact that the attraction of the different clientele that would be attracted to the pub, and the disagreements between the neighbours. I think it's great that Julian's got a long-term lease and he's done brilliant things with the pub at the moment. But I mean, Jeremy did make it quite clear when he was talking that if things didn't go well financially, then they would have to move on. And as we've mentioned, the license would still be held to the new owners. So that's it from me. Thank you.
Thank you. Oliver, have you anything you'd like to add at this stage?
Hello, can you hear me?
Yes, we can hear you.
Hi, my name's Oliver Fly. I live in 55 York Road. My garden backs onto the pub, back onto the pub garden. It's extremely loud in our bedrooms when people are in the garden. Obviously that quietens down when people go inside at 10 p.m. I strongly oppose any changes to the licensing hours, because, as I said, it will affect sleep. I agree with what's been said about the signs aren't going to make any difference. It's a very residential area. I don't think any of the residents really want people leaving the pub at 1 a.m. in the morning. So yeah, I'll leave it at that. I strongly oppose any changes to the licensing hours.
Thank you very much indeed for your contribution. Is there anyone else who'd like to say something that we haven't called? No, I'm not seeing anybody indicate. Thank you. All right, I think then if that is the case, we'll move forward. Do you want to just do us a close, Jeremy, or at this stage? Or Fee, please. Yes, I've seen you now.
Sorry about that.
Don't worry.
I don't know quite how this fits into the proceedings, so forgive me if I get this wrong. But
no, I'm sure you
a couple
will.
of questions to the applicant directly, because we haven't actually heard from you at all, Julian. I know you've got a solicitor and all that, but so is it 1 a.m. or bust as far as you're concerned? You know, would you be willing to consider somewhere in between your current hours and the 1 a.m. closing time? And is there anything you'd like to say yourself about the way you could manage the noise? Because I'm aware, you know, that Jeremy's talked about signs and so forth, but you know, license holding is a dark art, and I was wondering if there's anything you'd like to tell us about how you'd manage concerns around noise and people leaving and noise in the back garden, just so you get your chance to kind of tell us. You don't have to, but it's just an opportunity.
Good questions.
There we go, I've done it. Well done.
Right there.
Julian, do you want to come in?
Yeah, can you hear me?
Yes, we can hear you.
Yeah, so it's, I suppose, you know, being honest, obviously I got Jeremy, you know, engage Jeremy just because he speaks a lot more eloquently than I would, and will, you know, get the points across and knows the ins and outs. to your first question, 1 o'clock or bust, I would say it's not 1 o'clock or bust, because, you know, every conversation, of course, has an element of compromise in it, or I'd at least like to think so. The management of the outside, and I suppose it's just a moment to say as well, I really appreciate the nice things that people have said, and that people do get there's a difference from the previous owner to how we run the pub. You know, we're quite food led now. That's important. It used to be DJs. We don't have any live music, we don't have any DJs, and it is a very different clientele, mainly from people closer to pub, which is great. The management of it, and I completely take on board what everyone said, the management of noise, signs, yeah, we do have signage up. Bar staff really are a better way to control noise. You know, people actually saying to someone, can you keep the noise down, is much more effective than, you know, you could put billboards around the whole place. And I think actually someone telling you to be quiet is a lot more efficient. You know, we've got the same at the moment with all the rules with COVID. You know, you can put signs everywhere, but you need to tell people what the rules are. Because most people aren't trying to break the rules, but then when you remind them or you tell them, you know, this is how you need to behave. That's sort of what running a pub is a bit like. Sometimes it's a constant telling people, you know, what your expectations are. So that answers your question.
Thank you very much indeed. Right.
Sorry, Pete, one more very quick question. I'm sorry, not
yeah.
Sorry. It's just probably to Carl, actually. So once I take on board what people are saying about once a license is granted, it's granted in perpetuity to whoever holds it at that premises. Can you just quickly spell out, you know, should there be problems in the future, what steps local residents can take? Because they can make complaints and then the license can be reviewed again, as I understand it. Have I got that right? Just for everyone's clarification, just briefly, Carl, thanks.
Sure, Councillor, that's correct. So if the committee were minded to approve this application, or even if you refuse the application outright, whatever the situation is, where there's a licence in force, any person can make a complaint. That can go to the relevant council department or the police, and the appropriate enforcement action can be taken. In the most serious cases, this would probably lead to a review of the premises licence. Local residents also have the power to call for a review of the licence. It's not something you need another party to do for you. You don't need a solicitor. You don't need a council department to take the action, or the police. You can do it yourself. So if you found a premises was causing issues that were having a negative impact on any of the 4 licensing objectives, so in this case probably noise nuisance, you can submit a review application. It doesn't cost anything, and that brings the matter back to a hearing, effectively in the same format as this one, where your concerns are heard, and then the committee can take whatever action they deem appropriate. I mean, as you've heard today, in the last instance in 2007, that resulted in conditions being imposed to limit the use of the outside area. So that option is always available.
Okay. Just arising out of that, because I think it's important, that we must bear in mind that normal noise would not trigger a review. I underline the point that I've always saw, that it is a serious breach that are taking place that would review. You're absolutely right that, of course, people can write in and complain, and Mark Curtis and his team will look at it. But I think that one's got to look at a balance here of what we've got, because to get to the point of a review at this stage, when we're trying to get something that's workable and practical, I don't put in my Richter scale of saying that, oh, well, if it goes wrong, we can do a review. That would be a total failure of the whole situation, in my opinion. So just a word of caution on that one. I don't know. Good. Right. Could I come back to you, Jeremy, now? And perhaps you'd like to just sum up your applicant's views for us, and then we can sit down and deliberate on what we've heard.
Chair, sorry to interrupt. Do you want to ask any of the relevant persons if they want to sum up before we go to Jeremy?
You heard that? Do any of you wish to sum up at this stage? Which relevant person are you thinking of?
Any of the Mr. Best, they have an opportunity.
Sorry, Mr.
Miss Crispin or Oliver.
Oh,
or
I don't. I thought they were. They were.
I just
relevant persons is some like from our they've gone.
Yeah.
So, any of you, any of the residents who've written in, do you wish to sum up at this point?
I think we've said,
please.
Said what we wanted to say. Sorry.
Yeah, you've said what you want to say. Fair enough. Yeah, if we can go over to you then, Jeremy.
Yes, it's very brief, really. You've heard probably enough from me, and obviously you've heard from Mr. McLaughlin directly. As I said at the outset, we didn't want to cause probably the stir that we did with this application, and I think the point is this, that a variation application is somewhat of a blunderbuss by dint of how the government has said we have to deal with these things. As Mr. McLaughlin said, you know, it's not 1 a.m. or bust, and it is very much a matter for the committee to look at any kind of compromise or indeed impose any kind of condition that the committee feels is appropriate. I would just emphasise that there is evidence, plenty of strong management, and you've heard from Mr. McLaughlin with very, very rational and sensible answer to the councillor's questions of how do you best control noise. Well, you tell people. Most people are well-meaning and receptive. So that really, I would say, in terms of your evidential considerations, is important, along with the views of the police in terms of the extension, and also the comments that were made by Abby in relation to the extension of hours. So really, that in essence is the crux of the matter. As I say, it is a matter for you. We asked for 7 days a week until 1 o'clock. The reality is we're not going to have people in there at 1 o'clock in the morning, Monday through Wednesday, Sunday through Wednesday. Realistically, if there is an extension to be used, it's going to be on the days of possibly Thursday, the new weekend, as it was termed, and Friday and Saturday. So, as I say, really, that is the application, termed in very general terms, but hopefully through this committee meeting, it's identified possibly a little bit more of where we're coming from. Thank you.
Thank you very much indeed. If that's the case, then what I'm going to do is ask those that are not involved in the decision-making process to leave, and
they can't leave the meeting. Can you stay where you are? Sorry, Chair. We will put you in the waiting room, because if you
that's what I mean. You go into the waiting room.
We'll do that.
Leave this piece of it.
Yes, because if they do that, they won't be able to come back. Zoom's
we want them to come back.
Yes. So what will happen now? So if you could just bear with me, Ollie, if you can put all the parties back in the waiting room, and we will send you a message to tell you when we will be available to make the decision, and the committee with legal will now go into the breakout room. So we could be anything from half an hour to 45 minutes, but we will let you know if it's less. Okay, we'll give you some timing. So I'll ask Ollie, can you put everyone into the waiting room now and remove the committee to the breakout room?
Yeah, that's absolutely fine. I'll do so now.
Thank you very much, Ollie.
And
Can I get blue, please, Chair?
We're still live. We're still live. We're still live. Can you put us in the breakout room, please?
Yeah, sorry, I've got to manually select everybody from the list. Give me one moment. I believe that is it. Okay. You should all get a prompt on your screen. So Fee, we've got Chris is not on there. Absent, so Peter. We've got
Ollie, thank you. Thank you. Committee's just about to resume. We're just going to ask all the parties to return to the room to hear the decision.
Okay, let me know when you'd like to admit, and I'll do so.
I've clicked admit, Ollie, because I appreciate
great.
that your screen's having a few problems. Amara, can you just confirm that we're still live, please?
Yes, I can confirm that we are still live.
Thank you very much. So we have the applicant and applicant's lawyer and the relevant parties present. Chair, if you would like to proceed, Chair, with the decision announcement. Thank you.
Thank you very much indeed. Sorry for the wait, but it was quite a long one that we needed to get right. We have prepared a full statement that covers our decision, and I'll go through that, perhaps not fully, but touch on it, and you will receive in due course a written reply. Generally, there were two aspects of this application which we have considered separately. We first looked at whether it was appropriate for the promotion of the licence objectives to be removed and a condition restricting the use of the garden, which required it to be cleared by customers 2200 hours for smokers and could use it until 2300 hours. We noted that the public house was predominantly a residential area and the garden was surrounded by residential properties. The pub has been subject to noise complaints in the past, which resulted in a condition being imposed following noise complaints from use of the garden being upheld. Mark Curtis, Bristol City Council, clarified that this noise nuisance was not as a consequence of customers behaving in a rowdy fashion, but simply as a result of presence of customers in the garden area, mainly between the hours of 2200 and 23. Abibel Holman of our licensing team further submitted that there are no complaints of noise nuisance since the review. This we saw as evidence that the condition had been effective. Although the police agreed a condition with the applicant concerning the use of the outside area, there was strong opposition to removal of this condition from the licensing authority, supported by pollution control, who are the experts in nuisance, and a large number, and it was a large number, of local residents, some who live in very close vicinity to the pub. The Council's statement of licence and policy particularly addresses the issue of noise and disturbance from people outside and leaving the premises, which can arise even when these people are not behaving badly. This will be more significant in a residential area and will be more important after the hours of 2200. Therefore, the Council's usual starting point in regard to outside areas would be to impose a curfew at 2200 hours, unless the individual applicant can satisfy the licensing authority that an exception can be made to this policy without undermining its reasons that underlie it. Whilst we recognise that the current management have done an excellent job in turning the pub around since the review, we are of the view that to allow the outside area to be used beyond 2200 hours would pose a real risk of prevention of public nuisance and licensing objectives being undermined. During the later hours, ambient noise levels are much lower, and noise from even a small number of customers remaining outside is likely to cause nuisance in such a densely populated residential area, no matter how well the management try to control it. We are not satisfied that the exception to our policy can be made and do not therefore agree to remove or relax this condition. As far as the opening hours of the pub are concerned, we repeat our observations that to allow the pub to serve alcohol until 1 a.m. every day would adversely impact on the ability of nearby occupants to enjoy a good night's sleep. Although longer hours are intended to allow for a more gradual dispersal from premises, the evidence from residents is that the people leaving the premises later at night, even in small numbers, will cause a nuisance whilst remaining in the area, whether to smoke or waiting for a taxi to arrive. We welcome the concessions made on behalf of the applicant that he is willing to be flexible concerning the licensing hours and only likely to utilise the additional hours sought on a Thursday to Saturday. We therefore consider that it would be appropriate for the promotion of the licensing objectives, particularly prevention of the public nuisance, to leave the hours on Sunday to Wednesday as they currently stand. However, in order to strike a fair balance between all parties, we decided to allow a modest extension of licensing hours on Thursday to Saturday until midnight, with a further half an hour until 0030 hours, on which time all customers shall have to have left the premises. To justify this extension on the new weekend, as the applicants put it, we also considered it appropriate for the promotion of the licensing objectives to impose all the conditions the applicant has agreed with the police, save for the one concerning the use of the garden. In order to bring the licence up to date, we have decided to remove all embedded conditions that were carried over on the conversion from the 1964 Act. So that is our decision, which was reached unanimously. We see it as a reasonable balance and a way forward, and we hope it will allow you, Julian, to continue with a very successful and well-liked pub. Thank you very much indeed.
Thank you, Chair. Parties, I'm just going to remove you back into the waiting room and then you could leave the meeting at leisure because we're moving on to a different application now. Thank you very much. Chair, we're still broadcasting. Can we take a 15-minute break and commence again at 1 o'clock?
Yep, that's fine.
Agreed. Thank you. Thank you all. Thank you, Lynn. That was very helpful. Thank you.
Thank you.
Well done in the time.
Bye then for now.
Sorry?
Can you put yourself off video or on mute because we're still broadcasting. I'll ask the web technical team just to put up a screen to say that we're adjourned for 15 minutes, please. Committee members, are we ready to continue?
I am.
Lovely. If we could, just waiting for legal to appear. Chair, whilst I'm hoping Lynn hasn't dropped off, we could admit the people in the waiting room because I think we have.
Okay.
Can we admit them, please, Ollie? Thank you very much. And I'm hoping legal is still present with us. Sorry, I forgot to start my video. Just waiting for Councillor O'Rourke's audio to start. Lovely, starting. I'm just waiting to see if legal's with us. Lynn, can you hear us?
Can you hear me?
Yes, we can, Councillor O'Rourke. What I'll do is put you back on mute. Is that okay?
Yeah, absolutely.
Thank you. Michelle, can I just ask you to unmute and just check your audio for me? We are live, but I'd like to just check all. Can you? Lovely.
Can you hear me okay?
You can indeed, Michelle. Thank you.
Thank you.
Why is this not coming up? Tim, are you able to just check that we could hear you?
Yep, hi.
Right, lovely. Thank you. I'll just put you back on mute. And is that Mr. Fish?
Fiach, yes.
Lovely. You're part of the applicant. Lovely, great. Thank you very much. Chair, we have everyone that we ought to have. Good afternoon, everyone. The chair for this afternoon is Councillor Peter Abraham, and I will ask him to do the welcome and introductions. Thank you.
Thank you very much indeed. Welcome, everyone. We'll have some introductions in a moment. The procedure is quite straightforward. Normally at this time, when we're in committee, I give you loads of warnings where the loos are and fire and all the rest of it. But as you're in your own premises, I'm sure you'll be able to look after yourselves on that one. I think the main thing I say is, although we're on Zoom and we've done quite a few of these, they are successful and they work very well, but we want you to feel that you have your chance of making your representations or arguing your case, whatever you feel you wish to do, and we're happy to listen. If you've any questions or don't understand anything, please indicate, wave, do anything, and we'll stop and try to find the answers for you. Okay, the procedure is fairly straightforward. Let's do the introductions, then we'll come to the procedure because we'll know who we're dealing with now. My name is Peter Abraham. I'm a councillor and I'm the councillor for Stoke Bishop. I go along the line that I see on my screen. My colleague first, Councillor Hans.
Hello there. My name is Councillor Fee Hans. I'm the Green Party member for Redland Ward. Thank you.
And Carl.
Thanks, Chair. Afternoon. My name's Carl Knight. I'll be providing licensing policy advice to the committee.
Thank you. Michelle. Could you introduce yourself, Michelle?
Yes, good afternoon, everybody. I'm Michelle Hazelwood from John Gaunt and Partners. I'm here to represent Marston's PLC, who are the owners and operators of the Lost and Found.
Thank you. And will you be doing most of the introductions this afternoon and taking us through the application?
Yes, my hope and plan is that I will do most of the speaking. You have, as you can see on screen, Tim Carey and Fiach O'Rourke, who will be able to answer detailed operational questions.
Fair enough. He is introduced.
Excuse me, Chair. I think somebody has the live feed going on in the background and there's some feedback going on. Could you just have a quick check and make sure no one's broadcasting? Thank you. It's hard to concentrate sometimes. Cheers.
Thanks, Councillor. I was just about to check. So if you could turn off the YouTube broadcast, that causes the echo. Thank you.
Lovely. Mr. O'Rourke?
Yes, I'm Fiach O'Rourke. I'm the General Manager of the Lost and Found.
Thank you. And Tim?
Yeah, apologies, my surname didn't pop up. Yeah, Tim Carey. I'm the area manager, operations manager for Revere Bars. So I look after Lost and Found.
And Claudette?
Thank you, Chair. Claudette Campbell, Democratic Services.
Thank you. And Paula?
Hi, my name is Paula O'Rourke. I'm a councillor in Clifton, and I'm here to speak to my statement today.
And Lynn? Thank you.
Thank you, Chair. Afternoon, everybody. My name's Lynn Harvey and I'm legal advisor to the committee.